Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 25-5113 et al. Fairholme Funds, Inc., on behalf of its series, the Fairholme Fund et al., versus Federal Housing Finance Agency in its capacity as conservator of the Federal National Mortgage Association and the Federal Home Loan Mortgage Corporation et al. Appellants. Mr. Elwood for the appellants cross appellees, Mr. Hume for the class appellees, and Mr. Barnes for the appellees cross appellants.
Mr. Elwood, good morning.
May it please the court, John Elwood for FHFA, Fannie Mae, and Freddie Mac. In 2012, as Treasury's previously unlimited financial commitment was about to be capped, FHFA made the business decision to restructure Fannie and Freddie's dividend obligations to avoid burning through finite funding, making circular draws to pay fixed dividends. The Supreme Court unanimously held in Collins versus Yellen that decision to be within FHFA's authority under the Recovery Act's best interest provision, because the agency reasonably determined that the new variable dividend was in the public's best interests, even if it was against the interests of the enterprises and their private shareholders. That unanimous holding that FHFA acted reasonably and within its authority cannot be reconciled with a jury verdict finding the agency acted unreasonably. Put simply, a business decision that was within—
These are under different provisions, correct? The first was under the APA, and this is under a contract. Why can't that by itself be a reconciliation?
Because the statutory provision was incorporated in the contract. You can't look anywhere else for what that provision means than in the statutory provision, and it means the same thing both places. And it informs shareholders' expectations when a statute is put in place that is part of the contract and it reasonably authorizes the conduct that happened here. Shareholders just can't say that they didn't have a reasonable expectation that would happen. It was within the sweep of the statute. It wasn't a strange application. It was kind of a wheelhouse application.
Right? It was unprecedented, I think was the term.
The entire situation was unprecedented.
Well, that's true too.
The court said, and this court said, and the Supreme Court said that the powers that they gave were also quite strong, and they were not out of the ordinary. This is not your grandfather's conservator. It was empowered to act in its own interests. And that, I think, defeats the reasonable expectation argument in two ways.
That was true in FIREA too. Right?
Sorry?
That part was true in FIREA also. So, but here well, go on.
But it defeats it in two ways. First of all, the shareholders were on notice that the conservator could subordinate their interests to those of the agency itself and to the public. And under that circumstance, they may have had a hope that they would that their interests would be taken into account, but they had no reasonable expectation. Secondly, when you look at cases like Blaustein and Kahn versus Warburg-Pincus, the Delaware courts have held that when the contractual provisions that specify how it can be exercised, how that discretion can be exercised, there's no gap left to fill. And both of those cases involved circumstances where they said the party can act in its own interest exclusively. And that's exactly what this provision did, leaving essentially no gap left to fill.
The prior decisions in this court and in the Third Circuit that read Collins as leaving a potential gap, right? You're saying that was overruled essentially by Collins.
I don't know that Collins overruled it. It basically just filled in some of the detail. It said that this was a reasonable application on facts that were materially indistinguishable.
Correct. But Perry and Freeman had each said that there was room for an action under the implied covenant of the contract. But after Hera, but before Collins.
But the court was very clear on page 633, Perry 2, that it was whether plaintiffs stated claims for breach of contract and breach of the implied covenant is best addressed by the district court in the first instance. They basically said that the district court based its prior conclusion on an error of law, that because basically they didn't have an expectation of, they didn't have a right to dividends, they couldn't have an implied covenant claim. So they said that was wrong, do over. They didn't, say that they were foreclosing other possible arguments. Like, for example, this court also remanded on this idea that you had, that they had a contractual right to liquidation preferences. And the district court went outside the four corners of what this court decided and said, yeah, but that may be, you may have an anticipatory breach, but because it's unilateral, you can't recover on it. So clearly the district court was able to do other things. And here it's still open to it to consider other ways of skinning the cat. And one of those is the idea that this court sent back explicitly for whether it was in the reasonable expectations of the parties. But I think you can also face it as whether there was a gap to fill, and where the contract specifies a party can act in its own interests alone. That is enough. There's no more work for the implied covenant to do. And in fact, if you try to apply the covenant, it doesn't enforce the contract. It nullifies it.
One reading of that delegation of discretion is that it makes all the more important the obligation of good faith.
When it says that a decision is solely within discretion, there is case law in Delaware when it says it's solely in one party's discretion that they have to act in good faith. But as I say, Blaustein and Kahn both say that when they say the party can act in its own interests alone, that specifies how the discretion can be exercised, and there's no more work for that provision to do, for the implied covenant to do. And again, when the whole point of the Recovery Act was to allow the conservator to act in its own best interests, it does not enforce that contract to say, oh, well, you've got to consider the shareholders' interest too. That is making it your father's conservator again. And again,
it's saying that there's another source of law. You have to, just as you have to comply with both federal and state law, you have to comply with the APA and Delaware contract.
But in this case, the best interest provision provides the standard for both APA and for the contract. And again, it's pretty well established under Delaware law that if the party is able to act in its own interests alone, that's enough. And that's what
Which case is that?
Blaustein and Kahn versus Warburg Pincus, I think, are the best instances of that. And again, it's not enforcing the contract at that point to say, oh, well, you also got to consider the shareholders' interests. It's basically undoing the whole point of the Recovery Act.
So you would consider that it's impractical for FHFA to consider the shareholders' reasonable expectations?
It's not that it's impractical, it's that they don't have to, that they can act in the interest of the agency and in the public.
And how does that in any way restrain the conservator?
Well, it's obviously a broad grant of authority, but it's not so much that it has to restrain, although it does restrain. It says whose best interests you can act in, and that in itself is a restraint. But because it specifies how discretion is to be exercised, and that's where cases like Blaustein and Kahn come in, when it says explicitly, or rather when it says the party can act in its own interests alone, that's enough that there's no more work for the implied covenant to do.
And what's the status of the conservatorship?
It's still in place. We are now on our Fourth Amendment as of 2021. It's the Fourth Amendment, so the provision we're talking about today is no longer the governing dividend provision, but the conservatorship is still in place. In addition,
what replaced it?
The Fourth Amendment allows the companies to keep net worth. It allows it to build it up. Instead, they get what they were asking for here, which is dividends in kind. Basically, the amount of the dividend that would otherwise be paid is added to the liquidation preference, but they are allowed to accumulate assets under this beginning in early 2021. In addition, I wanted to just talk about the fact that...
What would that tell us about the expectations of a current shareholder?
Well, the expectations of a current shareholder, I mean, I don't know when you determine them from, but, basically, I think that the expectations of a current shareholder have both the Third Amendment and the Fourth Amendment baked in, which brings me to the last point I really want to make to the court.
But the Fourth Amendment would give back an expectation of some.
I don't know that it gives back an expectation. It gives an expectation that it's going to be, that it's being given now. And, but I don't think the court has to really talk about what the reasonable expectations are going forward, because we're not talking about the conservator's ability to act in the future, whether we could adopt a dividend provision.
But insofar as the 4617 restrains the court from doing anything that would interfere with the conservator's freedom of action going forward. We have to look, don't we, just to what exactly would be constrained if the plaintiffs prevail in this case.
I think if the plaintiffs prevailed in this case, it really doesn't say that much about discretion in the future, because again, we're not talking here, nothing we're asking the court to do here today, nothing the court has to do here today adds anything to FHFA's discretion. It's only basically saying whether this past act of discretion in adopting the Third Amendment is reasonable.
What do you make of this concern? I think you raised it, that that if the plaintiffs were to prevail, the effect on the capital structure of the agency would be somehow adversely affected.
Well, that's certainly true under the counterclaims, under the cross appeal rather, where they're basically trying to undo or trying to modify the capital structure to basically buy out all the preferred shareholders and the common shareholders of Freddie Mac.
Was that concern limited to the that cross appeal?
Well, I mean, in terms of like changing the capital structure, I think that that's the principle. If I understand your question correctly, that's principally where it's allowed. But the last point I really wanted to make here is that when we're talking about those reasonable expectations, this class undeniably includes people who bought low after the Third Amendment was adopted, and in full knowledge of the Third Amendment and the restrictions on the payment of dividends. And those people, bought low, they benefited as the share rose, and yet they would be class members able to recover under this, even though they, weren't themselves injured. The plaintiff's answer to that is, these claims travel with the shares. And I think that it is not so under both Virginia law and Delaware. I'd like to begin with Virginia. Under common law.
Just wait 1 second. Just be clear on this. I want to be clear. So there are purchasers both before and after the Third Amendment, but everybody is post HERA, correct?
There are purchasers both before and after the Third Amendment. No, there are probably pre-HERA, pre-Recovery Act purchasers who've owned since then. But our submission is that the people who, because this is, the class members are current shareholders when essentially, when the case is all wrapped up. So it could include people who bought in full knowledge, not only of the Third Amendment, but this court's decision. And our point is, I don't think there's any claim that those people have been injured by the Third Amendment, those people who purchased in full knowledge of it. It was priced in, but the idea is that it travels with the share. And under Virginia—
What does that tell us about the commonality of the class then? Did you challenge that?
We challenged a lot of it. We tried to get the class decertified, and in any event, that was defeated.
So you anticipate that if the plaintiffs prevailed, there would be individualized determinations?
No, all that is that there will be, basically the claim is that it traveled with the share, and so that they have the right to it because they have the rights of the people.
You're saying it would be a windfall.
And it would be a windfall for the people who bought with it already priced in. Would get a windfall to be like a claim that, again, is based on disappointed contractual expectations. There's no precedent for saying that such claims pass to people who know perfectly well what the contractual expectations are. Under Virginia, there are two ways I'd like to address this, because under Virginia law, the plaintiffs can't point to any case where a shows in action was automatically transferred from Virginia law. They just don't exist. And our argument is that Virginia—
There's no case either way.
There's no case either way.
Except we know that Virginia in general looks to Delaware law.
No, well, Virginia looks to Delaware law, but Virginia also looks to what the majority rule is. And that is Council versus Commonwealth 198, Virginia 288 at 292. There's no, I don't think there's any dispute that at common law, shows as an action, law claims did not travel with the share. There is also case law, both the Royal Park case said that the majority rule today is that under the UCC claims don't travel with the share.
And is that a Virginia case?
No, that is I honestly don't remember what law that is, but I mean, there's no law directly on point, but the majority rule, as Royal Park says, is that claims do not travel with the share under the UCC.
So I looked for and could not find any statement of the majority rule. I'll find it in that case.
Royal Park, you will find it. You will also find in the Pacific Life case a statement saying that very few jurisdictions have gone the other way. In particular, I'd like to point the court to New York adopted this rule early on. They had to adopt a different statute in order to get around it. California, I think that's the Pacific Life case. Ohio, after a fairly comprehensive review of the law, that's a Cheatham IRA case.
Wait a minute, you lost me. New York was getting around what?
No, New York court said the UCC, the claim does not automatically travel with the share under the UCC, so they adopted the general obligations law that allowed it to travel.
The general obligations law preceded the UCC.
Well, in any event, I couldn't tell you. My understanding was that
it was 1950.
No, but in any event, they adopted the general obligations law to get around that interpretation of the UCC. And the understanding is
it had to be of the common law. It couldn't have been of the UCC.
Perhaps so, but in any
event,
event,
they enacted the UCC. I would think the latter takes precedence.
But they wouldn't have had to adopt the general obligations law if the UCC already took care of it.
And does your position?
The UCC came later. That's the point.
After the general obligations law?
Yeah.
Well, in any event, we still have California law, Ohio law, and the Cheatham IRA. The Ohio Supreme Court comprehensively reviewed the law. There was a very good amicus brief there too.
And what about Erdan in Delaware? That's pretty clear.
I think, well, no, Erdan was a case about dilution, and the Activision case, I think, affirmatively helps us because Activision said both that B1, the kind of claims that travel with the shares are things that really inhere in the share, things like voting rights, where it doesn't make a lot of sense for people who don't own the share to have a say in voting rights. And that, as a consequence, B1 and B2 class actions are usually the proper mechanism for claims that inhere in the stock. B3 claims or B3 actions, like here, usually mean it's personal, Activision said. In addition, you have cases like Sun States where the court said that another Delaware case where they said that basically ordinarily, if it travels with the share, it's a claim for injunctive relief because you're trying to undo things that hurt current shareholders, not claims for damages. Well, again, is here.
That's not true with respect to future dividends.
Perhaps not with respect to future dividends, but I mean, the fact of the matter is, again, that it affects everybody differently. It's priced in differently, and so ordinarily it would not transfer. But again, Virginia usually goes with the majority rule.
I guess once we have the class certified and we're past that, right? I mean, it's not going to be individualized.
But in any event, I think that the type of claims, and you certainly can't point to a case where a claim of disappointed expectations automatically transferred with the shares because, it matters. I mean, it doesn't make a whole lot of sense to have such a claim transferred with the shares because it really doesn't matter so much to the current shareholder as it does matter to the person who held the shares at the time of the action. And I think that that's the difference between Erdan and Activision and cases which we prefer, which are cases like Savvy Volatility, where it was a claim for breach.
Savvy was a foreclosure case?
It was a breach of contract with respect to a past dividend. Yeah. But I mean, the fact that it was.
Yeah, you're right. Yes. Foreclosure case was Freeman, I think.
Mm-hmm. But in any event, I think that is a pretty good indication that, basically if it's already kind of baked in at the time, that's not a claim that would ordinarily transfer with the shares. And that as a consequence, it would be for whoever was the shareholder at the time of the action.
Based on FHFA's position, do we have to do anything with Perry 2?
No, I think, basically you can take Perry 2 as it comes. I think it strongly supports our position in two ways. I mean, it not only supports our position because it said, you have to consider the effect of the Recovery Act and the best interest provision on reasonable expectations. But it also said, a point we made in our brief, which was that even before the Third Amendment, FHFA was prohibited from paying dividends unless Treasury consented. And this court said that basically, as a matter of practice, that meant that only the Treasury was going to receive dividends under that arrangement, which plaintiffs have not challenged.
Now, insofar as your damages concern, you all didn't offer really any counter to the damages in terms of a calculation.
Well, I don't think we affirmatively proposed any additional damages other than we were the source of the event study that the plaintiff's expert then relied on in making its own presentation. But I don't know that we actually presented an alternative. I can have an answer for you in my rebuttal.
May I ask you about that study? You commissioned the study, correct?
We commissioned the study then with the other side.
Plaintiff's counsel introduced it.
I believe that that's correct.
You didn't have any objection to that.
I don't know if we objected or not, but I mean, we did, I believe, preserve the objection that basically that it didn't prove up to, reasonable certainty how a current shareholder of the stock would have been damaged by the Third Amendment. Both of the
gist of the report, as I recall, or at least one important aspect, was the claim, your argument that that the price rebounded.
That was that was something that was right in the event study. It was the third.
Also, then on the front end, that there were might have been other factors contributing to the loss on the day of the Third Amendment.
That's correct. In cross-examination, the plaintiff's expert admitted that there were two elements to the Third Amendment, one of which they did not challenge, which was basically speeding up the reduction in the mortgage portfolio, essentially reducing the size of their business. Yeah. And he admitted on cross-examination that he did not attempt to control for that, and basically you couldn't pass out how much was one and how much was the other.
Clarified on redirect when he was asked whether anything other than the Third Amendment could have had this drastic.
I don't think he was acted that. I think that they would shut him down because he didn't produce anything that said that on his expert report. So he wasn't rehabilitated on that. He didn't say anything along those lines. He had
already said all the different things he had considered that went into this judgment.
But he admitted on cross-examination he couldn't say how much was one and how much was the other. And absent that, the jury can't impose $812 million plus interest based on them eyeballing it and making a gut instinct about that it was more Third Amendment than reduction in the mortgage portfolio.
The rebound argument is something that comes out of fraud cases.
Yes, it comes out of fraud cases.
It doesn't have any application.
Oh, I disagree because it's a statement of essentially economic principle that markets frequently overreact on the day of getting news, and that over time, as they have more time to reflect on the actual implications, that the stock rebounds. And that Ross versus Walton, which is a district court decision in this district, dismissed because they basically didn't control or there was no reason to believe that that the initial drop reflected the true worth of the effects of the fraud, and that that you had to account for the tail end.
Actually, the things in the study, there were so many subsequent events, some of which were favorable and some unfavorable, that it's very hard to say that anything that happened in the rebound period, if that were relevant, or if it is relevant, was always indicative of discounting the effect of the Third Amendment.
But it's still, in order to produce reasonable certainty of what caused the injury, it's our position that essentially the expert had to say something about that. And because I anticipate that the other was, I will say we waived this by making certain stipulations. I would just want to point out JA 4497 is where the stipulation can be found on the record. And it said the defendants will not ask Dr. Mason, their expert, any questions about the price recovery. And defendants will not otherwise argue to the jury that the share price increases after the Third Amendment mitigated damages.
As you said, just to the jury.
Right, just to the jury, and also that it's not mitigation.
I don't think there's a forfeiture.
I like how you think. In any event, if there are no further questions, I'll reserve the remainder of my time for rebuttal.
The rebound argument that you make seems plausible. I guess I don't understand. Seems like the kind of testimony that an expert witness on your side would have offered, but you didn't provide an expert witness to the jury.
I don't think we provided a damages expert, but in any event, again, this is about a shortcoming in their own testimony. In Ross versus Walton, they dismissed the case literally at the 12B6 stage because they didn't account for the rebound. And so it's not anything that we have to prove. It's the other side has to prove it to show their damages.
But I mean, you're in a fraud case. No, this is not a fraud case, but there's usually be one expert for them, one expert for you. Their expert would say, look at this drop. It's because of the wrongdoing. And you'd say, oh, look, no, actually, it's not. Isn't that how? I don't understand why you didn't put.
Well, it's the obligation is on the plaintiff in order to prove it to a reasonable certainty. And this is only one of the two errors that we pointed out. There's also the fact that they didn't unpack how much of the drop was because of the reduction in the mortgage portfolio and how much of it was owing to the net worth sweep. So those are
true. You didn't even challenge the expert's methodology. You didn't raise a Daubert challenge.
I can't say whether or not we had a Daubert challenge. It's separate, but it's not relevant to this case. All we're saying is that they didn't explain away certain things and that they didn't account for certain things, that these are errors in their submission. This isn't a Daubert challenge. I also want to point out that their only Daubert argument I think it was in the 50B was, they said, this is really a waived Daubert argument and raised it in a footnote that was essentially unexplained. And I just want to point out that the case we cite in our own reply brief says that's not enough to preserve the Daubert type of claim. So anyway.
Just get a point of clarification. Are you finished?
I was going to change, so please get that.
Okay, back just for a moment to what travels with the shares. I think it's fair to say, I wonder if you agree, that at every state that one could consult, there are claims that do travel with the shares and others that do not.
No, I think the general rule is that claims don't automatically travel with the share, and that's all we're trying to say.
That is, I agree with that. Not all claims and not automatically.
The big thing is the automatically part, because we're not trying to contest any case where somebody said, I'm selling you my right to this claim. It's a question whether they travel automatically. Again, at common law, and the majority rule is that UCC claims do not travel automatically, and that this is not the type of claim that really inheres in the shares. The Delaware law recognizes travels automatically with the share.
On that topic, how is this a standing issue?
It's a standing injury because it's a question of whether or not there's injury. I think the best case on this is the Bluebird case, where Judge Mukasey said it was a matter of standing. Essentially, that if you were not injured by it, it's, they're just not a matter of constitutional standing, Article 3 standing.
Is there any at least loose analogy to a key tom where, you're the assignee, shows an action and the injury?
Well, I think the key time is sui generis. And there's separate questions about that. I mean, I guess it's been resolved for constitutional standing purposes, but, I think that if anything, the analogy works in the opposite direction, because there is a common law tradition of key tam actions, and under the common law shows as an action did not travel with the shares.
If we're trying to figure out a question of Virginia law that there's not Virginia precedent on, sometimes we would certify that question. I can imagine a lot of reasons not to do that here, but do you have an opinion on that?
I don't think we're going to go to the mat on that. We're not going to really say, no, we object vociferously. I think that it's unnecessary, and it would also probably add a year to a case that's already been hanging around for 13 years. And one thing I do want to point out is that in all of the cases that have involved cases traveling with the shares, I can't remember one that was certified. Everybody thought that there was enough to make an eerie guess, and I think there's enough to make an eerie guess here.
Fair enough. Giles. Thank you.
Thank you.
May it please the court, Hamish Hume for the class appellees and conditional cross appellants. Your honors, a unanimous jury found that when the FHFA agreed to the net worth sweep, it violated the implied covenant in the contract by arbitrarily and unreasonably violating shareholder expectations by changing a 10% dividend to a dividend of 100% of the net worth and profits of Fannie and Freddie forever. They also found that all classes of current shareholders were harmed and that a reasonable measure of that harm was $612 million. The defendants are asking you to reverse that unanimous jury verdict based on arguments that are, number one, at war with this court's decision in Perry 2, and number two, at war with the way in which they litigated this case, the decisions they made below. This court should affirm. Your honors, I'd like to start where Mr. Elwood started on the Collins decision and its use of the word reasonably. There's an old adage that courts ought to read sentences in a case, not as if they are shorn from their context, as if they appeared in a statute, but within the context of the case. I think defendants are guilty of violating that adage here in the worst kind of way. The context matters. The question the Supreme Court was asked in Collins was precisely the same question this court was asked in Perry 2, which is whether the allegations by the plaintiffs described an action by the FHFA that was so patently outside the broad statutory authority that HERA gave to conservators that it fell outside the bar on equitable or injunctive relief in 4617F. That was the question. Was it so far and so obviously outside the authority of HERA that 4617F would not apply? And in Collins, the Supreme Court gave the same answer that this court gave in Perry 2. No, it was not. And if you read this court's Perry 2 decision, page 604 to 616, where this court said that these actions fell within the statutory authority, and compare it to pages 237 to 242, where Collins gave the same answer, you will see that the two courts are saying the same thing. And Perry 2, of course, remanded our implied covenant. It's on no inconsistency with the two things. In the course of making its decision, the Supreme Court said that this was the type of action that the FHFA could reasonably do. That, in other words, it was not so patently outside the authority of HERA. That is the extent of what it said. It said, as Judge Lamberth correctly held on Joint Appendix, I think it's, I'll get you the site in a second, but in his summary judgment decision, it was a decision in the abstract of whether this was the type of action FHFA could reasonably take. That's it. We know it was not a decision that the FHFA, that the merits of an arbitrary and capricious claim, for example, under the APA, would fail as a matter of law because this was so reasonable. We know that's not what the Supreme Court was saying because it said it wasn't saying that. It never described its statement in that way. And the whole point of its ruling was to bar an arbitrary and capricious claim, and none was even presented there. It doesn't reference it. That is not what it is addressing. Even further afield from the Supreme Court's case than an APA arbitrary and capricious claim is a claim that the action violated the implied covenant. Because there, you're even further removed from an APA claim because you have to look at specific things you don't look at in an APA claim. You have to look at whether it violated the reasonable expectations of shareholders. And you have to look at factors that go beyond the statute, as this court said in Perry 2 on page 631, including statements FHFA had made. And so you also may look at whether the action was pretextual, as Judge Lamberth correctly said, which this court said on page 612 was irrelevant to the statutory authority inquiry. So we are at least two steps removed from the context and the question being presented in Collins, and its use of the word reasonably is no different from the way this court in Perry 2 said This is the type of action FHFA could do. It could, in theory, have reasonably decided that. That's the end of the inquiry for whether it falls under the statute and is statutorily authorized, and 4617F bars the APA claim. That's it. We know, in just closing on this point, we know two things for certain. We know that an agency action can be authorized by a statute and still be arbitrary and capricious. We know that from the structure of the APA and decades of case law saying certain actions are authorized by the statute, but still arbitrary and capricious in the way they were taken. So we know that's true. We also know that an action can be authorized by a statute and at least potentially violate the implied covenant in a contract that the agency has. And we know that from Perry 2's own holdings.
What is it about the way in which the power was exercised here that tells you that that it could be unreasonable as a matter of contract, although authorized as a matter of law?
Numerous things, Your Honor. For one thing, this was an unprecedented action, as all the experts testified. For another thing, when you combine the gravity of the action, giving away 100% of the net worth for all time, with the following fact, there was not a single memorandum or email even analyzing this question. The record is devoid of any, and the acting director admitted it. They never analyzed the pros and cons of the net worth sweep. They never analyzed whether the circular dividend was truly going to be a problem. They never analyzed whether there was really going to be a risk of erosion of the Treasury commitment. They never analyzed whether the market was concerned. They didn't ask anyone. They didn't consult anyone. It was two people, Mr. DeMarco, the acting director, and his sidekick, Mr. Ugaletti, who was simultaneously working for the Treasury Department. They consulted no one else. They never analyzed it. They never asked anyone to update projections. They looked at nothing. Third, they took that action in the face of repeated good news about page 2906 of the record, a roaring recovery that was expected. Sorry, that's 2573 of the record. Page 2575, Mr. DeMarco himself told the Treasury Secretary, we don't need the net worth sweep because we're going to be making profits above the 10% dividend well into the future. That's JA 2575. The Treasury Department, at page 2586 of the record, in a memo preparing Secretary Geithner to testify to Congress, they told him to tell Congress there's no problem with the circular dividends and there's no problem with the Treasury commitment being capped. We're going to have $275 billion. That's more than enough to give market confidence. No mention that they needed the sweep. But it gets even more incredible. Here's what actually happened. Between the time in June when Acting Director DeMarco told the Secretary of Treasury, we don't need the net worth sweep, we're making profits above the 10% well into the future. In late July, the second quarter earnings are calculated and before they're released publicly, sent to the Treasury point person on the Third Amendment, Timothy Bowler, showing, this is at 2906 of the record, very important document, showing that the profits for the second quarter were well above the 10% dividend and each enterprise was about to start building capital, rebuilding capital. And his response was, really makes sense to push the net worth sweep. It was the opposite of the circular dividend problem. It was the opposite of a concern that they weren't making enough profit to pay the 10% dividend that drove this thing. It was the concern that they were going to make profits above the dividend and start rebuilding capital. And the Treasury didn't want that. In fact, at 2954 of the record, you'll see in the Treasury's own announcement of this deal that the whole goal of it is to ensure these enterprises will not be allowed to rebuild capital. Now, the FHFA says, well, we had a different idea. look at 2933 of the record. The chief accountant, Nicholas Satriano, sends an email on the day he had a meeting with Mr. DeMarco and learns about the net worth sweep. And he has an exchange with one of his colleagues. And he says, there was discussion by both boards about reversing the accounting write-down for these massive deferred tax assets, which the email doesn't say, but other evidence does, were worth tens of billions of dollars, a one-time huge write-up of net worth. And he says, I don't think that makes sense because the amendment, the net worth sweep, is designed to demonstrate wind down. That's the FHFA saying that, just like Treasury is saying, hey, they're making profits above the 10% dividend, really makes sense to push the net worth sweep. So there was no analysis of the claimed problem of dividends below the 10% dividend, the need to take circular draws, the erosion of the commitment, the secondary market has concerns, not a single shred of analysis, nothing, not even an email. And on the flip side, you have emails basically saying this thing was driven because they were making too much profits, and they knew they were going to make too much profit because they had taken massive accounting write-downs from 2009 to 11, leading to record losses, but paper losses. And what happens to paper losses when the economy rebounds and the housing market rebounds, and it turns out you were way too conservative? Record profits. And you can see them. You can see that in the record too, that they say we're going to have a roaring recovery. JA 2573. We're going to have the golden years of earnings, JA 2657. They knew this was all predictable, what would happen. And in 2013, it happened. They paid dividends.
What are the dates of the
All
pages you just cited?
everything else I said was in before the net worth sweep.
Right, but how close in time?
July of 2012. The roaring recovery email is maybe June or July.
And the Third Amendment?
Third Amendment was August 17th, 2012. So everything I've said about,
So a year later, the same year.
so then, no, the same year. So all the evidence I gave you of what they knew and why it was predictable that they'd have a deferred tax asset write-up of tens of billions. They knew there'd be a roaring recovery when these accounting losses turned into accounting gains. They knew they were heading into the golden years of earnings. Those documents, again, 2573 of the record, 2657 of the record, those were all before the net worth sweep. And again, 2906 is when they see actual profits, the first sign of this, above the 10%, and they say, ooh, really makes sense to push the net worth sweep. Treasury says that. And 2933 shows that FHFA shared that view. And then another piece of evidence. In 2013, the first year it took effect. It was signed on August 17th, took effect January 1, 2013. The dividends paid to Treasury were 100, under the net worth sweep, were $130 billion of cash.
I think the claim in Perry too was 180 billion. Is that right?
I don't remember the 180 number, Your Honor, but the point I wanted to make is that's 111 billion more than it would have been under the 10% dividend. Our expert analyzed this at 1220 to 22 of the record. He talks about this. There is not a single email or evidence that anyone at FHFA expressed the slightest concern or surprise about this. None. We asked Mr. DeMarco that. So you can learn what someone's intentions were at the time, sometimes, by how they react after, is the only point I'm making there.
Can you talk about the Article 3 standing issue?
Yes. So, Your Honor, I think there's ships passing in the night a little bit here. There's no question that there is a conceptual difference established in the law that between personal claims, like a securities fraud claim or a tort claim or a claim that has something to do with what you were misrepresented into buying or selling the property, a personal claim versus a claim that inheres in the security. That's especially well established in Delaware law, but it's recognized in other cases too, including their cases. If you look at their Con Edison case, it talks about that. If you look at their Savvy case, it talks about that. If you look at their Cheatham case from Ohio, it cites Erdon, or maybe it cites Activision, acknowledging this principle, and it never says Delaware is some weird outlier. They keep saying Delaware is a weird outlier. There's not a shred of authority for that. They didn't cite nothing to you that says Delaware is an outlier. It's just more developed for obvious reasons. So this clear distinction in the Erdon decision from the Supreme Court of Delaware is the best articulation of it and the most fleshed out articulation of it. And it says, amongst other things, that the key to a claim is whether it impacts the relationship of the share itself with the corporation. So it's an injury to the stock itself. Dilution claims fall into this category. A breach of employment compensation plans fall into this category. Breach of the corporate certificate fall into this category normally. And so all of their authority about shows in action doesn't pass automatically. All of it, when you look at it, is dealing with personal claims, fraud claims, tort claims, the types of things that are personal to you, and it's merely incidental that the tort done to you relates to a share of stock, as I think Erdon says, or Activision says, it might just as well be land or a car. Those personal claims do not automatically assign. Delaware says that too. But the claims that are an injury to the stock itself that fundamentally change the relationship of the stock to the corporation, those inhere in the security and they travel with the shares. Delaware says that plainly. Their own cases cite to that principle without criticizing it. The only thing I'll say and acknowledge is we don't have a case from Virginia that addresses it either way. There's no case in Virginia that addresses the type of claim that inheres in the security and says it travels with the share or that it doesn't travel with the share. But they have no case from any state, anywhere, that addresses a claim that Delaware would say inheres in the security and it doesn't travel with the share automatically. They have nothing. So I realize maybe your question was more focused on Article 3, but this is the predicate for their whole Article 3 argument.
No, I appreciate the answer and it's helpful, but you're right. I also want what you're anticipating my follow-up question
Yes.
would ask you to answer. Well, let's say that I buy stock after the Third Amendment. At that point, the value of that stock reflects the effect of the Third Amendment. It just doesn't seem like the Third Amendment has cost me a penny, and that I get to come to court and have Article 3 standing.
Yes. And the answer to that is actually in the portion of our briefs that deal with their argument that we didn't show harm to current shareholders. We do have Article 3 standing in this. I'm going to answer your question, and I just want to make clear, in answering it, I also show why their whole standing argument is not jurisdictional and should be waived. I'll come back to that. But to answer your question is, when it's an injury to the stock that is inextricable to the stock, and here it's a permanent alienation of the private shares from the profits of the companies. They're saying, just to be clear, the net worth sweep says, no matter how much money Fannie and Freddie make, trillions upon trillions, the number go to the top. All of it goes to Treasury. And by the way, that's true under the Fourth Amendment too. The cash builds in the company, but every cash of profit they make becomes an increase in the senior preferred stock liquidation preference. And this was put before the jury in the trial. This Fourth Amendment isn't new from the trial. It was presented. It's just a different way of doing the net worth sweep. It gives them the liquidation, the senior preferred stocks principle, if you will, the liquidation preference goes up by every penny of net worth. So it's an injury to the stock that never goes away. It doesn't matter what you do with that stock. It's impaired because the net worth sweep says, yeah, you think you own stock, but actually you're alienated from the profits of the company. And when that kind of injury is done, it injures anyone who owns it. Anyone who owns it. If you own that stock today, okay, if you went out and bought it today, sure, I take your point, and I'll come back to this expectations point. You will have bought something that is permanently alienated and that cannot participate in the profits. That means that you are, in fact, injured because that stock can never be what a true share of stock is supposed to be. So you have injury, and you also know, the other thing is not only is the net worth sweep still in effect, you also know that the net worth sweep has caused the companies to send Treasury all these massive, over $151 billion of excess dividends above what it would have sent under the 10% dividend.
Could a member of the class does the class include someone who bought the stock after the Third Amendment and sold the stock before the complaint?
I just want to make sure I got that. Could you repeat the question?
Someone bought the stock after the Third Amendment and then sold the stock before the suit was filed here.
No, the classes are defined as the current shareholders.
Okay.
So no. And I think another way of looking at this is, and Judge Lambert says this brilliantly in denying their motion, in their 50A motion at the first trial. The defendants are trying to get you to confuse the injury here with the measure of damages. The injury is to the stock. As he says, the drop in stock price is not itself the alleged injury. This is JA 525. Judge Lambert says the alleged injury is that the net worth sweep effectively eliminated the dividend rights that came with the shares as they were originally issued. In other words, when someone buys a share in a company, they're purchasing a bundle of rights. And plaintiffs are arguing here that the net worth sweep removed one of the most valuable sticks from that bundle. That's a type of claim that travels with their shares. The drop in stock price is just a measure of damages. That's the key to understanding why it's not about whether you bought or sold at a gain or a loss. It's the fact that you own stock that is impaired, that gives you Article 3 standing. It's impaired by the existence of the net worth sweep, and your harm is confirmed by the effects of the net worth sweep, transferring this extra $151 billion. It would be worth more today if the net worth sweep were undone or remedied in any way.
But you would have paid more for it.
But then you wouldn't. But then you wouldn't have had the. If you wouldn't.
Just imagine that I bought the stock after the Third Amendment, and I held on to the stock, and nothing changed afterwards. This is a hypothetical, obviously. So the value stayed exactly the same. And then this verdict comes in, and there's a judgment, and I get paid, and then I sell the stock, and it's for the same price I bought it for. That just seems like such a windfall for me. And I get that you're saying, well, it's kind of the stock, not the person, but like stocks don't file lawsuits and have standing under Article 3 of the Constitution. It's the person who does.
Sure. And to be clear, all of our class representatives owned their stock before the net worth sweep and still own it today, just so you know. So in terms of Article 3, all of our class representatives.
Well, but not the class members.
The class is, well, that may be relevant. I'll come back to why. But the other thing I really think the disconnect we're having does boil down to the fact that the injury we're complaining of, as Judge Lambert said repeatedly, but including at JA 525, is not an injury of buying high and selling low. It's not an injury based on the stock price. Stock price became relevant only as a reasonable measure. The injury we're claiming is that everyone who owns this stock owns an impaired stock. And you may be right in terms of the intermittent trading in the stock, but if it weren't for that, people would have been hurt even more. But
I just don't get, I get that you're saying it's an impaired stock, but like, you could have an impaired car. Like if you buy a lemon and you know it's a lemon when you buy it, doesn't seem like you're injured because now you own a lemon.
Well, I think what I would try to do then is take you back to the Supreme Court of Delaware's decision in Erdon, which says that the plaintiff there, or in Activision, sold the stock and then continued to sue. And they said, it's not a personal claim. When you sold that stock, you lost your claim. It went with the shares. Nothing about that decision had anything to do with the price paid for the stock. It's just the concern you're having is foreign to the analysis that's well developed in Delaware law for when a claim travels with the shares. And I really want to emphasize how important Erdon is, and that no case from any other state has criticized that. They haven't found one. And if you shepherdize it, you'll find it followed all over the place, including in at least one California case applying California law. So that's the central concept here. And I think,
Mr. Hume, the point is illustrated by the market in the shares of bankrupt companies that are hoping to go through recovery and a reorganization.
it is illustrated. It's consistent with that.
It happens all the time. Happened to Avis a couple of years ago.
That's right.
It's an active market in shares that may be worth nothing and they may be worth a lot. It's true of Russian bonds, Tsarist bonds, Argentine. Now that's all debt rather than equity, but same idea.
I think that's
The
absolutely
federal
right.
assumption of the state debts after the American Revolution was preceded by a feverish market in those expectations, because soldiers had sold off their scrip thinking that it would never be worth much.
I think that,
Speculators who thought it might be.
well, I think that's correct. And I think a decision that doesn't recognize that does real risk of harming how financial markets work, and that you do get the rights in the shares, including claims that inhere in the security. And if it weren't for that, I think it would really disrupt how financial markets work, Delaware law being so well developed on this point.
Now, obviously, you're here to hold on to your jury verdict, but as to the individual damages, restitution damages seem to be prohibited by 4617.
Judge Childs, my colleague, Mr. Barnes,
Okay.
is going to address the cross appeal on
Okay.
reliance restitution. I do just want to note, we can join that condition on the judgment not being disturbed, which we think is the right result. If Judge Lamberth had allowed the reliance damage claim to go forward, we could have presented both theories. So we shouldn't lose the theory we were allowed to present. We should be allowed to go back and present the theories Mr. Barnes is going to.
Why did you cross appeal?
We joined the cross appeal.
Okay.
We were simply,
So was that brief on your behalf as well?
yes, we filed a joinder notice
No,
saying
no,
we,
in this court, is the Berkeley brief one you joined?
yes,
Okay, thank you.
just with the condition that we don't want to disturb the existing judgment.
Yes, of course.
It's a conditional joinder. Your Honors, if I may have a little more time, I'd just like to address one or two things that came up in Mr. Elwood's argument. 4617F, barring the clause. He didn't start with that, but their brief starts with it. Very briefly, Judge Lamberth held in 2014 in his original dismissal that it allows damage claims. This court, they didn't appeal that. This court also made that decision on page 631 when it remanded our implied covenant insofar as it seeks damages. And on page 613 to 14, specially emphasized that in response to accusations from the dissent about how the majority was disregarding the rule of law, Judge Brown's dissent, the majority said, what do you mean? We are remanding the claim. We're only talking about certain remedies being prohibited. You can seek damages, and we're remanding this claim on damages. So it's a holding of this court that can't be disturbed, and Collins does nothing to change it. Collins was purely addressing an APA injunction claim, just like this court was. In fact, it even calls 4617F an anti-injunction clause.
I read the parties as having agreed that whether you call it equitable or legal, whatever it is, it's a functional question of whether it interferes with the conservator's authorities.
I don't think, yes, I think it's whether it's injunctive relief versus damages is the distinction, not necessarily any other labeling, which is what Jacobs, the case they rely on from the Third Circuit.
Well, I think the phrase we used was injunctive, declaratory, or other equitable relief.
That's exactly the phrase you used on page 612 of your opinion, and we agree with that. Whereas a damage claim is different, and every court has said that. Even the case they rely on, Jacobs, says that. On page 895 of Jacobs, it says most damage claims are okay, including breach of contract claims, and it cites to Perry too. The only thing that was different in Jacobs was the claim there was a disgorgement of every single penny paid under the net worth sweep. And the Third Circuit said, yeah, that's basically the equivalent of injunctive relief, so we're going to draw the line at that. But that's not this case. This case is a damage claim that's equal to less, the verdict is less than 0.5% of the excess value transferred to Treasury. 151 billion of excess value, a verdict before interest of 612 million. So it's very different from disgorging every single penny. A final point is there is law, this wasn't cited in the briefs, that a prior panel decision, when addressed by a later panel in the same case, should be especially mindful of the law, not just the law of the case, but the law of the circuit doctrine. And an intervening Supreme Court decision should not be read to change that unless it's clearly eviscerating.
Mr. Chairman, one more question going back to our previous discussion. Any chance you know the proportion of damages that involved post-sweep purchasers?
We don't know that. The question is, if you take the class today, what percentage bought post-sweep? That was not a point developed. And if you'll allow me to just use that as a launch pad to answer a question and similar point, that this whole issue of standing, which I think is not jurisdictional for the reasons I've given, I know we've addressed that. The defendants not only stipulated to class certification, the judge, this didn't come through clearly enough in our briefs. The judge was not willing to accept the stipulation. He's like, this is class certification. I don't let you just stipulate. And so the parties conferred, and this is ECF 135 of the class docket below. We said, what we want, instead of a stipulation that treated our motion as withdrawn, treat our motion as filed. And but the defendants asked us to narrow the certification. We sought it under all three subsections of B, B1, B2, B3. They said, narrow it to B3, and you can say we don't contest it. We don't oppose the motion. And our motion made clear that it was premised on the idea that the claims traveled with the shares.
So if I go to ECF 135, I'll find all of this.
You'll find that they don't oppose our motion for class certification. And then you can look at our motion, which I can give you the JA sites for. But our motion makes clear that it's based on traveling with the shares.
While you're looking for that, I'm just going to check and see if any of my colleagues have any more questions.
Yeah, it's JA 4462 and surrounding pages is our motion. And the order is at JA 2216 to 17 is the relevant pages.
Okay.
Your Honors, one last case very quickly. Mr. Elwood, on this implied covenant discretion point, we cite pages on page 27 that he acknowledged that it's precisely when a lot of discretion is conferred that the implied covenant is most important. He said, no, look at Kahn and Blaustein. Please, Your Honors, read Blaustein, not their brief on Blaustein. They give a very misleading description of Blaustein. It doesn't talk about a provision in the contract.
Okay, I'm going to cut you off there. I appreciate it.
Right.
That issue is well briefed, as were almost all the issues. So appreciate it. I'll let you go on a long time because it's a complicated case. So I'm grateful for the.
Thank you, Your Honors. Thank you.
Good morning, Your Honors, and may it please the court. I'm Brian Barnes for the Berkeley Cross Appellants. I'm principally here to talk about restitution and reliance, but given some of the colloquies with other counsel today, one thing I just want to point out factually is that many of the shares that are the basis for Berkeley's lawsuit are shares that it owned before the financial crisis. So these are shares that Berkeley purchased going back to 2005, 2006, 2007, and still owns. And I just think that's an important point to keep in mind, that there are shareholders involved in this litigation that have owned all along, even going back before HERA. With respect to restitution, obviously the district court didn't let us pursue restitution because of 4617F. And the point I want to emphasize here is that we are not asking the courts to do anything by way of ordering the defendants to do anything other than pay money. The restitution remedy, the only effect that it has in terms of what the defendants would be ordered to do is pay money. Now, we recognize that as part of the logic of the restitution remedy, there would be a corresponding release of the defendant's ongoing contractual obligations to Berkeley, but that does not restrain or affect, within the meaning of 4617F, the conservator's exercise of its authority. Releasing the conservator and the GSEs from a contractual obligation is the opposite of restraining or affecting the conservator's exercise of its statutory authority.
Even if the court order just said pay money, would the next thing that is legally required to happen be a sale of shares? In other words, like an elimination of the shares?
Well, I think there's an important distinction there, Your Honor, between a sale of shares versus an elimination of shares. The functional consequence of restitution here would be effectively the extinguishment of the shares, because the contractual obligations of the defendants to Berkeley would go away. But I would submit that that's very different from a scenario where a court directs the conservator to sell or purchase some kind of asset. And that's cases like this court's decision in Freeman.
It would alter the capital structure.
It would alter the capital structure, Your Honor, but what I would submit is that conceives.
What does that mean? You mean the number of shares outstanding would be reduced?
That's exactly what it means. It means the number of shares would be reduced, but critically, what we would not be having the court do is order the defendants to.
Once the number of shares are reduced, would Fannie and Freddie then need to take additional actions to make the ratio of, I don't know, debt and cash? I don't understand how it all works, but my impression is that there are laws that require them to have a certain, equity ratio.
I think those laws are suspended during conservatorship, but regardless, it is true that if we got the restitutionary remedy we're asking for here, there would be accounting consequences for the books and records of Fannie and Freddie. The SEC filings would reflect a different number of outstanding shares of these junior preferred shares, but that is not really meaningfully different from a scenario where a court orders the defendants to pay money, and the defendants, in order to fund the judgment, they have to go out and borrow additional money to pay the judgment. That's going to show up in the accounting records as well. And
is it true that we're talking about $48 billion?
That is true, Your Honor. One thing I would note is that this is. Basically what we're asking for here is it's a large amount of money, because it's a large amount of money that the defendants raised when they issued these shares. The other thing I'd note.
But putting aside the connection, legal reasoning that gets you to your argument for restitution, the result would be, if I'm asking, would not the result be, then you would be compensated to the extent that you paid for the shares?
We'd be compensated to the extent we paid for the shares, less dividends received on the shares. And so the calculation is a little different series by series, depending on the amount of dividends that have been paid.
And so if you paid 100 for the shares, but when the Third Amendment was adopted, the shares had been diminished in value by 93%, and so the market value was 7. You would nonetheless be receiving 100.
That is the logic of the
100 minus the dividends received.
That's the logic of the restitutionary remedy, Your Honor, and I would submit that that's not so different from the investors back, as Your Honor referred to earlier, in the Revolutionary War times, who bought up Revolutionary War debt at a steep discount, and ultimately those investments paid.
Your claim sounds inequity.
We don't think the claim necessarily sounds inequity. That said, we don't think that the distinction between law and equity matters here. What matters is,
insofar as a remedy is inequitable, it does.
Well, that may or may not be right, Your Honor. I'd point the court to the second restatement on contracts, section 373, comment D, that talks about losing contracts and whether you can get restitution on a losing contract. That restatement takes the position that for losing contracts, there's not a problem in terms of the remedy being inequitable. Here, we don't think the remedy is inequitable. The government was able to extract $151 billion more.
But if your objection is to the Third Amendment, as I understand it is, and the Third Amendment confiscated your property when it was worth 7, not 100. I do think you're having difficulty with a district court sitting in equity.
Well, that's an issue that obviously wasn't the district court didn't reach. We don't think that that's an issue that the Court of Appeals ought to decide in the first instance. Again, these shares were ultimately issued by Fannie and Freddie. Most of them, they raised $25 a share. The damages award from the jury amounts to, for the series that were $25 a share par, something like 61 or 62 cents a share. And so to the extent that there's a windfall here, we think that windfall is going to the government, which it was able to extract $151 billion out of these companies it couldn't have otherwise gotten absent the net worth sweep.
The district courts say, I guess it was with respect to rescission, that the remedy would be inequitable.
The district court suggested that with respect to reliance. Again, we don't.
Reliance, thank you.
Right. We obviously don't agree with that view, but the district court didn't reach this question of what windfall with respect to restitution.
Right. Although it's hard to see why there would be a difference when the numbers are essentially the same.
Well, and there's also a question at the threshold of whether there's even an appropriate sort of windfall inquiry as part of the restitution analysis. We don't think there is. And again, I just point the court to that.
It's not part of the restitution analysis. It's a separate equitable consideration.
We think the restitution remedy, our entitlement to get our money back fundamentally, or we're the successors in interest to the people who originally purchased these shares for $25 a share, doesn't depend on that sort of windfall analysis. And again, second restatement on contracts, section 373, I think strongly supports that.
373.
Yeah, comment D.
But what does Collins say about the equitable claims?
Well, Collins, neither the Supreme Court's decision in Collins nor this court's decision in Freeman had before it the type of remedy that we're specifically asking for here, which is a remedy where the only order that's directed to the defendants is an order to pay money. There's just a corresponding release of contractual rights on our side of the V. So that's just we would submit the key inquiry under Collins, under 4617F is the court ordering the defendants to do something other than pay money? And here the answer is no.
I can see if we have any more questions, Judge Childs.
Oh, your reliance damages. Are you still fighting for those?
We're still pressing the reliance argument, Your Honor, and there, we've spent some time dwelling on the concept of a windfall. The way reliance damages deal with the windfall problem is the defendants would be, under a reliance theory, entitled to come into court and prove, okay, this would have been a losing contract. Here's how much you would have lost. It's just that the burden is on them rather than us to make that showing. And we think this is really the prototypical
But it
case.
seemed more like that was a discretionary decision by the trial judge about how late you brought up that claim.
Well, and we brought up the claim exactly when the federal rules required us to. We did exactly, in trying to raise the claim, we did exactly what we said we would do in our initial disclosures. So I point the court to JA 194, where it was literally exactly the thing that's contemplated there is what we tried to do. The other thing that's important to keep in mind here is just the sequence of events. The summary judgment opinion that said we couldn't present our flagship theory of expectancy damages came after the pretrial statement was due in the case, just right on the eve of trial. And it was The first trial,
The first one.
that's correct. So it was within 5 days of when the district court issued its summary judgment opinion that we said, okay, our flagship theory of expectancy damages, we haven't been permitted to present it to the jury. And so we want to use our fallback theory of reliance damages.
Thank you, Mr. Barnes.
May it please the court. Listening to Mr. Hume talk about the evidence that was introduced at trial, and listening to him discuss the case, I was put in mind of the complaint in Collins, which uses pretext and actually says pretext in as many words, and how the case was litigated throughout. Both this case, Perry 2 itself, specifically addressed this issue that it was pretextual, that it really wasn't done for the best interests of the companies. And Collins specifically addressed that. You can pull the complaint off of the Supreme Court's website. You can see how it was addressed at argument there. That complaint, that entire case was soaked in allegations of pretext. And same here. This court addressed the pretext discussion on page 611 and 612, and it said, the stockholders cite nothing, nor can we find anything in the Recovery Act that hinges FHFA's exercise of its conservative discretion on particular motivations. The shareholders were on notice that they were entitled to act. Basically, they were able to act in the public interest, and they could subordinate their interest to them. All that they have proved is that basically, they basically said, aha, this was done for some other reason. But all of that was before this court, both in Perry 2, and it was certainly before the Supreme Court in Collins, and it didn't undermine the decision. The reason why that matters is for two. For two reasons. Again, the shareholders knew that the FHFA was able to act in its own interests. In addition, Mr. Hume may have said that we misrepresented Blaustein, but he didn't say that about Kahn. And Kahn made clear that if the contractual obligation says a party can act in its own interests alone, that eliminates the implied covenant. And that is precisely what happened here. I would like to now ask, subject to the court's questions, head on to this issue of standing and whether it travels with the shares. First of all, to answer Judge Ginsburg's question earlier about the Royal Park and the majority rule, this is on page 49 of our brief. Quote, the majority rule is that there is no automatic assignment of an accompanying litigation right or claim when transferring property, unquote. That's Royal Park at page 398. Mr. Hume says that basically that's for personal rights, and it's not for rights that inhere in the share and the relationship of the people to the shareholders to the company. But Activision, I think, said it most explicitly, and this was true of the Erden case as well, that those are claims, things like voting rights. And of course, voting rights matter to the person who holds the share at the time, because, you want that right to vote. And as in some states, it says those are normally done through injunctive relief, not through damages remedies. And, the idea that it's anything other than a personal right when you're claiming that basically the value of the stocks drop because of action that's already been taken, that's the sort of thing that is a personal right. It's like savvy volatility, where it's a breach of contract for something that has already happened.
Judge Ginsburg mentioned an analogy to bankruptcy. Can you talk about that?
I have to say I didn't quite follow that, because the idea is, though, that basically whether you have the right to it and whether it's a personal claim. And, I don't know enough about bankruptcy, but the point of our argument here is that if the claim goes to anybody, it goes to the people who bought the stock not knowing of the network sweep and then sold it. Now, clearly they can transfer it. It just doesn't transfer automatically. Now, let me see here. And also Erdan was a dilution claim. So again, it has to do with the stockholder value. Now, I'd like to talk about this idea that we somehow waived this by stipulating to the class certification. Class certification happened after the judge had already decided that the injury travels with the share, or the claim travels with the share. We're not supposed to, dig in our heels and never let anything happen ever again in the case that is at war with that. And in addition to that, when we stipulated, we reserved the right to argue that individual class members were not injured, which is what we are saying here. When essentially their claim was narrowed from a claim for dividends, including future dividends, things that would matter a lot to current shareholders, to a claim of lost value that occurred at the time of the net worth sweep, we immediately moved to decertify the class. And the judge there didn't say you waived it. He just said, no, you're wrong on the merits. And if you look at the 50B motion, he denied that on law of the case with an air of impatience because he was tired of hearing the argument. So the idea that we somehow waived this, I think, is simply not so. And if there are no further questions, we'll rely on our submissions.
I do have one question that was mentioned. The topic that was referenced earlier. If Fannie and Freddie are exempt from Dodd-Frank while they're under the conservatorship?
I do not know, but I mean, on the counterclaim examples, I mean, the idea that it's not just sort of some sort of bookkeeping entry. I think the logic of their explanation is that there would basically that Freddie Mac, it would buy out all of the preferred shareholders and all the common shareholders who didn't opt out, which would mean basically what was previously a public corporation would now be essentially a government corporation with a handful or however many opt-outs there are of individual shareholders. And the idea that changing these companies from, public corporations as they have always been, it was part of the goal of appointing the conservatorship, is to preserve their role as public corporations and to convert them to government-owned entities with a little bit of common shares in Fannie Mae is just, I think, kind of ridiculous. Of course, that is going to affect the exercise.
Like the Third Amendment
of the conservator shares. There's still billions of dollars of worth there. These shares closed yesterday for $8. That's a 2,200% increase from before the Third Amendment, and $8 for Fannie, $7 for Freddie. So, I mean, I wish that most of my investments would do that well. Thank you.
Okay. Thank you.
Case number 25-5176, Samara L.A. Simmons, appellant versus United States Department of State. Mr. Deming for the appellant, Mr. Georgia for the appellee.
Good morning, Mr. Deming.
Thank you, Your Honor. For the record, my name is Stuart Deming. I represent the appellant, Samara Simmons. I'd like to reserve 3 minutes for rebuttal. And at the outset, I am suffering from somewhat of a hearing disability due to a bad cold. So if I ask for clarification, it's not due to a lack of respect to the court. Background here in this particular case are 5 FOIA requests. 3 were issued in the period of 2016. 1 for the Department of State's medical unit. The second relating to the unit involving human resources. And a third relative to the consulate in Juarez, Mexico. 2 more were issued in 2019. 1 was for the purpose of securing verification of a settlement that had taken place in March of 2019. That was prompted by the prior indication of the State Department that the only way for my client to secure access to her security file was through a FOIA request. Secondly, the other 2019 request arose out of a request for an IG report that was issued. The complaint sought the records that had been referred to the main unit at State, IPS, for records that underlie the report of the IG. So essentially, we have 5 requests that are at issue. My focus today is principally on the issue of causation. 2 of the requests, the one that relates to the 2016 request of the Consulate Mexico, and the 2 May 2019 request for the DS security file were, in my opinion, not addressed by the district court. And opposing counsel in his response has not indicated otherwise. The second issue in terms of eligibility is the standard that was applied by the district court. That standard district court relied on solely related to delay as the factor that it had to look to in terms of determining causation. It did not include unilateral or discretionary disclosures that took place on the part of the State Department. And again, opposing counsel has not, in his response, has not suggested otherwise in terms of what the standard should be. Why that is relevant is that the district court made findings of 4 supplemental productions that took place after it had represented in its filings that it had completed production of all responsive records. Those supplemental findings indicated that the findings were at the behest of my client, Ms. Simmons. Those findings, in my view, are categorically contrary to its holding that there was lack of causation. Based upon this court's prior holdings, causation is reflected when there's been a discretionary or unilateral change in the position on the part of the government.
But does your argument discount that there were a substantial amount of documents that were produced prior to the filing of the complaint?
In that regard, we totally disagree with the district court. The judicial admissions filed on the part of the department indicated that there was a single pre-litigation disclosure, and that related to a HR request, and that was made in December 10th of 2018. Consistently, the filings, both in the joint status reports and as well as the answers on the part of the department, were consistent in that regard. The court found otherwise. It relied upon a declaration that we believe was fatally flawed in that respect.
But that doesn't answer my question about did you receive a substantial amount of documents prior to the filing of the complaint?
As to the request at issue, there was no responses other than the December 10th, 2018 response. Now, the court looked to other disclosures in suggesting that there had been prior disclosures. But for example, as to the medical request, there was a response, but it responded to a different request, not the request that's currently before the court.
But there was a disclosure of the same information as was sought in the other request, second request.
That's correct, Your Honor. It was a partial response as to that.
So if not, what you just said makes me uncertain of the answer that you're giving. If you request a particular type of information, let's say my own medical records in one request, and then later ask for something different, but I receive my own medical records, the first request has been satisfied, even though it comes in response to a different request.
Essentially here, the two requests were identical. What happened is the State Department refused to provide her with her personal medical records. And what State Department insisted, which is highly unusual from my point of view, they insisted upon receiving a FOIA request to get her own personal medical records. So what happened is the same request that had been previously issued in 2016 was used for the September 2016 request. The medical records were produced as to that second later request that was made at the behest of the State Department. The first was already there. So the request asked for both personal records as well as any records relating to what had happened to this woman in terms of the illegally obtaining her medical records. We never received the second category until after the complaint was filed.
But at that point, or at least ultimately, every request was fulfilled. The question, as you say, is causation.
Yeah, ultimately, every request was fulfilled in that regard. One, of course, in fact, even as to the medical records, we didn't receive some of the medical records until 2023. There were like 26 pages of documents that were turned over.
So supposedly there's a joint status report dated October 24, 2018, a statement that the State Department produced over 1,000 pages. So were any of those pages in response to the 5 FOIA requests that you're speaking of?
Yes.
Okay. And then your complaint was not filed until July 11, 2019. So you've gotten 1,000 pages before your complaint is filed.
I think I misunderstand the question. Those 1,000 pages that are referenced actually refer to an administrative hearing document. It was a status report relating to an EEO case. It was not the joint status report filed in this case. So there's a misunderstanding in terms of what actually happened. Those 1,000 documents were produced pursuant to a request made, a 2016 request that was made involving records of the diplomatic security. That was before the settlement was reached. After the settlement, we went back and said, we need to see what happened. Did they expunge records according to the terms of the agreement? That was 2019. Have I answered your question?
Yes.
Yeah, I mean, that document has been misinterpreted as reflecting what had happened in this particular matter. It relates solely to another EEO case that was produced solely to show that unrelated documents were produced unresponsive to these requests at issue here.
It's very unusual for anyone to publicly release their medical documents. So I expect the answer to this to be no, but I just want to make sure there's not an intention to publicly release the medical documents, right? I mean, you don't plan to release the private medical documents?
Absolutely not. In terms, we put, it's been cited by opposing counsel's brief, we put the government on notice that as these documents are turned over, some of them were highly personal and that steps needed to be taken in order to protect the.
Right. And that makes total sense. I would do the same. My next question though is, why does the public have an interest in a FOIA request for documents the public will never see?
Well, as to the substance of the medical records, that's fair, although the record would show that records were produced by through the Justice Department by email that actually contain these records. But as to the ultimate question I think you're asking, what we were trying to achieve is to show the dynamics associated with what had happened. These records were improperly taken or requested from the medical provider in New Jersey against the advice of lawyers at the State Department. And they were brought back and then they were disseminated to various units within the department. And that's the basic thrust of one of the things we've been trying to achieve, is to figure out what exactly had happened in that particular case.
Even if we were to agree with you that there was a violation of FOIA, you're asking obviously for the attorney's fees. Is that something that we would review? Or is that something that would go back to the district court?
Our position is that it would go back to the district court. Our view is that the issue of entitlement goes back to the district court, which this court had previously held that entitlement issues are generally first addressed at the district court level. We believe that there was causation and that the next step is to reverse and to go back to the district court for both issues.
And just to be clear, you are saying none of the 1,000 pages were related and that anything that you received only came after the complaint?
The 1,000 pages were related. Let me be clear on that. Of those 1,000 pages, there may have been pages that were responsive to the HR request, the December 10th, 2018. What occurred was there was trying to reach a settlement. So basically an understanding was reached between the department and the lawyers. We will expedite this DS 2016 request so that you can go through those records and make a determination as to what is to be expunged. Within those 1,000 records, I believe a fair statement would be that the one request that the department has included in its answers to the pleadings was a response to the December 10th, 2018. So that set of documents would be within that 1,000 pages.
And that's approximately how many pages?
284, I believe, roughly.
And so then there's also the issue about some of the delay being caused by COVID and also the sheer number of requests, that there's just a backlog and that backlog still exists today. So you don't think that plays into their decision-making on how to process these claims?
Well, it may have, but for example, COVID came after the complaints were filed. So all three complaints preceded COVID. As to the delay that took place after, the last supplemental production took place in April of 2023. And even in the state's own declaration, the cause was the fact that the internal units within the agency failed to work with one another. It was a lack of cooperation. Had nothing to do with workload, so on and so forth. The other supplemental productions that took place, we raised the issue of the question of whether their exceptions were appropriate. State changed its position and released the records. Those are classic indicia of causation. And now three of the four supplemental productions were done almost immediately once the issues were appropriately raised.
Judge Childs, any other questions? Judge Ginsburg? Okay, thank you.
Thank you.
May it please the court. My name is Assistant United States Attorney Dimitar Georgia for the United States. This court should affirm the denial of attorneys' fees for two main reasons. First, this court can apply its precedent in Cotton versus Heyman to affirm the district court's denial of attorneys' fees because by her own admission, Ms. Simmons submitted FOIA requests in support for her employment actions against the Department of State. And separately, independently, this court can affirm the district court's denial of fees because the district court did not abuse its discretion when it found that the FOIA litigation did not cause the production of withheld records because the district court found that state had made substantial pre-litigation productions, which findings this court reviews for clear error. Much of opposing counsel's submission today focuses on factual disagreements with the district court. All those factual findings are reviewed for clear error, and there is sufficient evidence in the record that substantiate the court's findings. Specifically, the fact that there were not just one, but 7 separate productions that had been made of records, various responsive records, prior to the finding of the litigation. The district court specifically found in analyzing the language of the various FOIA requests that those FOIA requests were overlapping and in certain instances identical. It then found that responsive records had been produced, crediting a declaration from the Department of State to that effect. Looking at the answer from the Department of State, but also to the joint status report submitted by the parties, as well as evidence that Ms. Simmons had presented in her petition for fees. Crediting all of that evidence, the district court found that there was substantial evidence in the record of prior productions, and it found, as a matter of fact, that the litigation did not cause the production of records. That is sufficient under a clear error standard for this court to affirm. Opposing counsel suggests that the district court did not separately evaluate each record, each FOIA request. There are 5 of them. But we point to first how the parties presented their arguments, particularly how Ms. Simmons presented her arguments that treated all requests together in her fee petition, as well as during the litigation below. And in the opinion on page 2 of the opinion, that is Joint Appendix 346, the district court actually qualifies in how it is addressing, for example, the 2016 requests. And it begins by saying that there are 3 requests that were filed in 2016. And then in terms of the 2016 requests. And then when it conducts its analysis at page 8 and 9 of its opinion, it evaluates the language of the 2016 requests that were issued in this litigation against the different FOIA requests to which the State Department had responded and had asserted that it provided responsive records. And it said that those records were responsive to the 2016 requests. Opposing counsel also emphasizes judicial admissions that were presented in an answer in litigation. First, the answer in a FOIA request is intended to preserve waivable defenses. It does not state the litigating position or the position of the Department of State or of any department of how it is processing the request. Again, there is a factual finding that state was already producing records when the litigation was initiated. The answer merely establishes the preservation of certain defenses in the first joint status reports filed after the case was already in the district court. State clearly indicated that it is processing the request, and there was no indication that there was any intent from the State Department not to release any records. But there's an additional reason why this court should reject the emphasis that plaintiff places on the answer, and that is found in Grand Canyon. In Grand Canyon, this court said that the mere initiation of litigation is not sufficient to establish causation. The complaint is the document that initiates litigation. The federal rules of civil procedure require an agency to respond to that complaint. Failure to respond can be read as admitting to the allegations in the complaint. And so in a certain sense, then if we do it, then if we don't file a answer. If we file an answer, then we're responsible for, the agency is responsible for attorney's fees because it has taken a certain litigating position. If it doesn't file an answer, then the agency might be liable for injunctive relief, which is the typical remedy that a plaintiff seeks.
And how many pages would you say you produced prior to the filing of the complaint?
The record is not entirely clear. There's not sufficient evidence that at least I haven't been able to find.
So do you think it was less than 1,000 and closer to the almost 300 that plaintiff suggests?
Again, Your Honor, that the record does not indicate exactly how many pages were responsive. The district court, however, did find that those prior productions included records that were responsive to the FOIA requests that were issued here, and this court reviews that factual finding for clear error. But this court can also look to the entitlement. And Judge Walker, you asked a question of whether the public should be liable for fees when a plaintiff seeks records for their own benefit. It shouldn't. And that's precisely what Cotton said. When a plaintiff, and then this court has reaffirmed that maxim, for example, in Davi, when this court said, those who seek documents for private advantage cannot deserve a subsidy as they benefit only themselves and typically need no incentive to litigate. Certainly there is a fourth element in the analysis of entitlement under Cotton, and that is the government's reasonable basis for withholding. The court did not, the court below did not address entitlement. It did not make specific findings as to the reasonableness, but this court can look to the district court's findings on the delays in the prior productions in its analysis under eligibility and import those factual findings into its analysis of entitlement. And therefore, this court is then only left with the straightforward application of Cotton, which is a question of law, in which this court can certainly make here, and it has done before in Cotton.
So when the correspondence states that documents should be released in full, does that mean that they are included Or are they, is there a contemporaneous production or supplemental production that just keeps continuing?
Can you repeat your question, Your
Like,
Honor?
if you have any correspondence that would suggest that documents have been released in full, is that a complete production or is it a rolling production that there will be more documents to come?
I think that would depend on the context. Certainly, we maintain that in this case, there were documents that had already been released pre-litigation and that there was an ongoing production of records. At the conclusion of the rolling productions, then the parties did engage in discussions of whether the productions were complete, whether certain withholdings should be waived. There was some disagreement over certain withholdings. There was also some disagreement over the completeness of the productions. Ultimately, all those questions were resolved by the parties without any court intervention. Indeed, the district court did not, other than decide the motion for fees and receive joint status report at certain intervals, the district court had no role in shepherding the parties through their discussions, and there's no indication that the litigation in any way contributed to the parties resolving their issues.
Mr. Georgia, one of the first thing you said related to circuit precedent, no fees in certain FOIA requests. Was that the prelude to the argument you've made about entitlement, or was that something else?
That is to entitlement. Yes, Your Honor. The case is Cotton.
Okay, thank you.
3 weeks ago, the Department of Justice announced that it thinks the Presidential Records Act is unconstitutional. Do you know if the department has a view on whether FOIA is constitutional?
We have not argued that in our briefs, Your Honor.
Any other questions?
Thank you.
I believe the question was asked as to when the department indicated that it had completed production. At A89 of our joint appendix, there's reference to a joint status report that was issued or filed on May 23rd. Of 2023. And there in paragraph 4, it's asserted as of November 29, 2021, the defendant's production is complete. And then the next 4 paragraphs identify the 4 supplemental productions that took place after the fact. 2 of those related to a change in position as to exceptions. 1 was an accommodation, and the 4th was the addressing the delay of 4 years in order to find the documents related to both of the 2019 requests. As to the issue of the reference to the fact that the district court argued that there was an overlap in the productions of the 2016 request, and that it took the position that the responses to the unlitigated 2016 request could be used as a basis for finding that there had been a response to the litigated 2016 request. This court, in a case which I mispronounced, Colasac 73 Feds 3rd 389, basically took the position that in response to a FOIA request, a unit of an agency is only obligated to respond to that, to what's within that unit as opposed to the department at large. So I believe the district court erred as a matter of law in her interpretation. Lastly, there's reference made to entitlement, that this court should dig into entitlement. The department relies on McKinley and indicating that this court can proceed and address entitlement. McKinley actually involved a case in which the district court did address entitlement. The district court skipped the issue of eligibility and went to the issue of entitlement. So in McKinley, when this court addressed it, it was not engaging in fact-finding on its own. It was reviewing what the district court had done in that particular case. Sorry.
Judge Childs, Judge Ginsburg? No. Thank you.
Thank you.
Case number 25-8509, Henry Larry Elliott Klayman. Mr. Klayman, on behalf of the respondent.
Good morning, Your Honors. I sat through these two oral arguments and I want to commend you on your thoroughness. It's something which I think the American people appreciate. I'd founded Judicial Watch many years ago, and I believe that judges are our most important public servants. That's the way I do what I do. But this is a very important case. It is manifest injustice in many respects. This case stems from my attempts to gain pro hac vice entry into a very high profile and controversial case involving the standoff at Bunkerville with Klayman Bundy. I applied, it was denied, and the lower court found that I had not been candid with the court. The fact is that we had, when it went up to the Ninth Circuit, a very independent jurist, I might add somebody who's not of my ideological ilk, Judge Gould, who said that I disclosed everything I needed to disclose, that I'm an advocate, that it was zealous representation, and that I didn't do anything wrong. But unfortunately, the DC bar, the disciplinary apparatus, and I mean this in a humble way, has become very partisan, and we know that. I'm a conservative activist. I support President Trump. In the age of President Trump, the DC bar has gone after a number of lawyers like me. I'm only one. I'm not going to dwell in that because Your Honor is considering reciprocal discipline. You have an independent authority and duty to decide whether that is warranted or not. Otherwise, it would have been a fait accompli, and I wouldn't be here today. What's important here is that three things are in play. One, the entire disciplinary proceeding had nothing to do with the District of Columbia. Absolutely nothing. It was about my conduct in Nevada. I was never sanctioned by the district court. I was never sanctioned by the Ninth Circuit. In fact, I won the appeal for Bundy when his indictment was dismissed. And I was never, ever even referred to an internal court disciplinary proceeding. That underscores the partisan nature. And this court has made a very important ruling, it's the Douglas case, that when there's viewpoint discrimination, which there is here, and I brought a separate lawsuit on that, which is still running through your court, that in fact, this was a violation of my constitutional rights. I had not just the testimony or the findings of Judge Gould in my favor, but Erwin Chemerinsky of Berkeley, University of California at Berkeley, Bolt Hall. None of these witnesses are my ideological kin. But Chemerinsky also found that I did nothing wrong. I did not make any misrepresentations. And the number of pleadings that I filed is not a reason to sanction me or to suspend me for 18 months. Now, this is another factor which is very important for this court, is that the DC disciplinary apparatus, that's what I call it, the ad hoc hearing committee that heard this could not find an ethical violation after the hearing. And that was put in writing in an order. 4 years later, almost half a decade, when President Trump's coming back into office, they come up with 1 year suspension. And what they're alleging are very petty things. I submit that I did not commit any violations. If there were a few inadvertent errors, that's all it was. But you don't get sanctioned for 18 months for that. And what's important here is that if your honors do not recognize that the DC bar had to follow the rules of its own court, both of the District of Columbia Court of Appeals and the board, which used the word shall, a decision had to be made, a recommendation by the ad hoc hearing committee within 120 days. They took 4 years. Then you're making a ruling that people don't have to observe your rules either lawyers or litigants. So this is an important case precedentially for this court itself, because the DC Court of Appeals basically said, doesn't matter that we use the word shall, that you shall make a decision in 120 days to recommend it. We can do whatever we want. We have unbridled discretion. Well, that's not the way things work, and it's not the way this court works. What is important here is that by waiting 4 years, they were stacking disciplinary proceedings. In Florida, in a case, and I cite this in the brief, Florida Bar versus Rubin, that's illegal. Florida's recognized that. That's a distinguished court. Other states have recognized that. What they did, the District of Columbia Bar Disciplinary Apparatus, the board and the DCCA, they held back until a prior suspension, which I'm also challenging, which is unjust, which I don't need to get into this here as well. Also the result, partisanship, was over. So what do? They start a new one. And that's this Bundy case. And the prosecutor basically has said, Julia Porter, she had no witnesses at all. And in fact, that's why I got a finding after the hearing that there was no showing of an ethical violation. That's very rare after a hearing at that level to make that decision. Your Honor looks at 4 factors in reciprocal discipline. Lack of due process. If you wait 4 years, what happened at the ad hoc hearing committee, memories fade. People forget what went on. Consequently, what was adopted was just the brief of the District of Columbia Office of Disciplinary Counsel, which then went up to the board, and the board gives that deference. They rubber stamp it, and then the DCCA rubber stamps it. But what is really strange here, in addition to everything else in the age of Donald Trump, is that they upped the requested sanction to 18 months without any valid basis to do it, with a reinstatement provision. At the same time, someone like Kevin Kleinsmith, who pled guilty to a felony, who falsified a document which gave rise in large part to the Russian collusion investigation against the president, he got a slap on the wrist, 7 months temporary suspension, no reinstatement, no problem. But he's on the other side of the political spectrum. So too for David Kendall of Williams and Conley. So too for Mark Elias. Williams and Conley admitted that they helped Hillary destroy the 33,000 emails. Someone filed a complaint. That was thrown in the trash. Elias did other things. No problem for him. So this is a question not just of a lack of due process after 4 years, but second factor, there's an infirmity of proof. And Your Honor, I'm sure will review my brief carefully. We gave you record sites. We gave you the transcript. Is that how can you find that I did anything wrong when it didn't even involve this jurisdiction, never sanctioned, never referred to a bar in Nevada, never referred to the court. This was pulled out of the hat because as Larry Klayman, the founder of Judicial Watch and Freedom Watch, public enemy number one, to the ideology of the District of Columbia Bar disciplinary apparatus. And you can check FEC records to see what that is. Then the third factor is this would result in a grave injustice. And for all of these reasons, Your Honor, and I say what you're going to, I look forward to your writing something here, because you see these things, it's not just what goes on here, but then it creates reciprocal discipline in all the jurisdictions that I'm a member of. Florida, that's another one of my primary jurisdictions, as well as District of Columbia. Northern District of Texas, Ninth Circuit, Fifth Circuit, Middle District of Florida, all the courts, Southern District of Florida. This has consumed me with time and expense, keeps me from representing clients. And one of those reciprocal discipline proceedings resulted in a suspension in Florida when they never got into what went on here. It was just, okay, this is what DC did. We'll do it too. Well, I know this court's not going to do that because you are a scholarly court, and that's why, and it wasn't gratuitous that I complimented you watching these oral arguments, because you did read what was presented to you and you did make a reasoned factual decision. So what you're going to write is precedential, and it's precedential with regard to whether this court is going to make a ruling like the District Court of Appeals, that you don't have to follow rules. Again, the rules 12 and others, both of the court and of the board, say that you have to make a recommendation in 120 days. Here it was 4 years, almost half a decade. And conveniently, only when someone who's perceived to be a supporter of President Trump, and I am, and I'm not in any way embarrassed to say that, someone who is and has always been on the cutting edge. You all know who Judicial Watch is.
I think you're on the third of the 3 points. I want to make sure that you don't run out of time.
Okay.
I want to hear your fourth point as well.
Well, the fourth point is that lack of due process, infirmity of proof, reciprocal discipline would result in injustice, and that Your Honors have the ability to decide what sanction, if any, there should be. You have that independent authority, and here there should be none. And in particular, and I emphasize this, how can it be that there should be a sanction here when Nevada never sanctioned me, the Ninth Circuit never sanctioned me, when Judge Gould and Erwin Chemerinsky said that I did not fail to disclose anything, and that I had a right because I wanted to defend Klayman Bundy, who faced life imprisonment, and he had a right under Sixth Amendment to have me as his counsel. And then ultimately the case went up to the Ninth Circuit. I defended Bundy there when in fact his indictment was dismissed at the lower court level and won. So that's very important. And I would turn your attention to pages.
Mr. Klayman, may you take about 1 more minute, please?
Yes, pages 2 of my brief, where I quote Judge Gould saying that I properly disclosed what was at issue in the ongoing disciplinary proceeding, that there was no deception. Page 7, where he talks about sometimes lawyers have to be a little bit combative with judges. This judge was criticized for violating Bundy's constitutional rights, that's understandable in a criminal case. And then Judge Gould, I quote him there as well, Klayman had no greater duty to disclose any possible blemish on his career or reputation beyond responding to the district court's further requests. So that's the argument. And I hope that Your Honor, will exercise your independence in making a ruling here and write down the reasons for it, because it would also be helpful for the other jurisdictions. Thank you very much.
Just a couple of questions.
Yeah, sure.
On the 120-day statutory deadline, that rule doesn't impose a consequence if it's failed to meet it.
That was the specious argument of Bar Counsel. The District of Columbia's statute of limitations has no consequence. There's no penalty. So by analogy, that should have no penalty either.
Okay.
Thank you, Your Honor, for asking that question.
Okay, and then with respect to your the process claim, you had notice, you had your opportunity to be heard. So are you really saying that this delay is prejudice to you?
Yes, it's prejudicial. It creates stacking where they could stack on something else after I was already clear of another suspension. Florida Bar versus Rubin. You can see the reasoning in there and its progeny in other states as well. And also memories fade. 4 years later, how do you remember what went on at the ad hoc hearing committee? At that point, I don't know who wrote the decision. You take the brief of disciplinary counsel, who presented no witnesses, and you just rubber stamp it, and that's what happened here.
And then just quickly on your manifest injustice claim, you're suggesting that it's unconstitutional, but it wasn't really clear as
Yes.
to how you're saying so.
And there is a case that I filed at the district court, which is now up here on appeal. And it deals with the Douglas decision that your court rendered here, which dealt with a matter years ago. It's now been ratified or adopted by the U.S. Supreme Court just in the last few weeks, that if you take an action based on someone's political or ideological views, it can be a violation of the First and Fifth Amendment. So, Your Honors, even, you also have the option here of staying what you're doing until that is fully litigated. And if you look at Exhibit B of our appendix, there are a number of articles there written on both sides of the political spectrum about what's going on here with the DC bar. And what's also interesting is President Trump sanctioned a number of law firms because he perceived that they opposed him with the Russian collusion. This court and other courts have reversed those sanctions based upon viewpoint discrimination, based upon the fact that those law firms have a different ideological perspective, political perspective, that there was retaliation by President Trump. It goes both ways. And it's very important in this atmosphere that we live in, which is highly partisan, highly combative, that this court make a stand on that, because the DC bar disciplinary apparatus is being abused right now. And I suggest, or I ask you to read those articles, and there are many more on Appendix B of what's going on right now. It's widely recognized that it's being used as a weapon under the new disciplinary council. The old one, Wallace Shipp, was not that way. It was a fair man. The new disciplinary council, Hamilton Fox, is highly partisan. Jeffrey Clark was found by the board of professional responsibility to be subject to being disbarred because he wrote a letter which he never sent to Georgia. What could be more absurd and unfair? Rudy Giuliani was disbarred because he made a few errors in pleadings. There are complaints pending against Senators Josh Hawley and Ted Cruz for supporting President Trump in the 2020 elections. Kellyanne Conway, Sidney Powell, John Eastman, a respected law professor, subject to disbarment here and in California. This is what's going on, and someone's got to put a stop to it. Thank you.
Thank you.
God bless.
Stand, please. This honorable court now stands adjourned until Tuesday, April 23rd at 9:30 a.m.